on behalf of Daniel Mehrmann.
Thank you. All right, at this time, Mr. Horner, you may begin your argument.
Thank you, Your Honor. May it please the court, we are here for a case that involves an administrative review of an opinion and order of the Illinois Educational Labor Relations Board that was issued and served on July 16th, 2025, which affirms the administrative law judge's recommended decision and order that was issued and served on March 31st, 2025. Decisions made by the Illinois Education Labor Relations Board involve a mixed question of law and fact. Therefore, the standard of review when reviewing these cases is a clearly erroneous standard. The issues before the court today that we like Your Honors to review initially is if the Illinois Educational Labor Relations Board clearly erred when they determined that Daniel Mehrmann established a prima facie case for violating Section 14-A1 of the Illinois Educational Labor Relations Act. And the second issue is if Mehrmann had proved a prima facie case for violating Section 14-A1 of the Act, whether the record demonstrates that the college would have discharged Daniel Mehrmann from employment for legitimate business reasons, regardless of his protected activity. As an initial matter, Section 14-A1 of the IELRA prohibits employers from interfering, restraining, or coercing employees in the exercise of the rights guaranteed under the Act. Therefore, they cannot interfere with an employee exercising their protected activities, and the employee can establish a prima facie case by showing that their activity was protected, the employer knew the protected concerted activity, and that the adverse employment action was motivated by the employee's protected concerted activity.
Mr. Horner, could I ask you, and I'm asking this question with respect to the college in general, not specifically as to Dr. Becker, but when did the college know that Mr. Mehrmann did not have a master's?
I believe it was in the spring of 2022. There was a conversation between Dr. Kristen Rupert, who had recently taken over for dean of the college, or she was chair of the college, apologize. She was having a conversation with Ed Jacobs, and Ed had informed her that well, let me back up, I apologize. They were discussing the minimum requirements needed to teach the courses. Kristen had indicated that a master's is required. Ed had told Kristen that Mr. Mehrmann did not have a master's.
Well, what is Ed's position with the college?
He was the chair of the department.
Okay, so I mean, the college's knowledge comes from its agents and employees, so it knew, the college knew, and that was kind of the premise of my question. I don't know if somebody else discovered more recently, but the college knew because Jacobs knew. How long did Jacobs know?
Is unknown, Your Honor. It could be that Jacobs didn't understand the new minimum requirements. The requirements for a master's just took place, or was implemented in March of 2020. So it was fairly nuanced, and it could be that Jacobs did not know that a master's was required. In fact, when Kristen Rupert had brought it to his attention, it seemed as if he did not know. And
the fact that this person, Mr. Mehrmann, didn't have a master's, it's hard to imagine that not being known when he first applied to teach at the college.
I agree, Your Honor, and it wasn't always a requirement. The requirement,
correct, but it was known, and so the confluence of that knowledge and the requirement is what, 2020?
Yes.
And if I could follow up on that, Justice Doherty, if you've completed your questioning on that issue. I mean, was there any evidence that the college presented that they had ever really taken the time to evaluate whether a master's degree would be required for teaching the music technology courses? And I guess a sub question is, especially in light of the fact that you were converting it to a certificate program, it seems that experience in these practical type courses might be more appropriate, or might be at least allowed, if you will, versus a requirement of a master's. So was that evaluation ever really done? And was there any evidence in our record about that?
There's no evidence regarding a evaluation of whether one is needed. The Illinois Community College Board, ICCB, and the Higher Learning Commission, they implement those minimum requirements. So it's not really so much the college evaluating a program and making the determination whether that program would necessitate a master's degree. It's more so these are the minimum requirements set forth by the Higher Learning Commission. Therefore, we need to abide by that. I hope that answers your question. As for the sub question, obviously experience counts and matters when determining employment. However, the employee himself or herself would need to demonstrate that they're a good fit. In this case, Daniel Mehrmann had lost all seniority. He had failed to teach any classes in the spring of 2021, therefore resetting his equated hours. And he had demonstrated, at best, reluctance to kind of be a team player, and at worst, he was insubordinate. There are instances in the
Well,
record.
but if I can just interrupt, but nevertheless, he was the one who really got the program going in the first place, did he not? And helped develop this program at the college?
He did, yes.
And taught many courses in that program throughout the years before this incident and these events occurred.
That is correct. And I don't think there's any dispute as to whether, he was qualified as far as understanding the subject material. The issue just came where he did not have a master's as required by the Higher Learning Commission. And there was a drastic decrease in interest in the program as a whole. So the college decided to eliminate the program entirely. And that's one of the reasons why Mr. Mehrmann was terminated.
But there were some courses that were part of the program that were still being taught after it was, quote, terminated. Isn't that correct?
That is correct, Your Honor. If I may,
Counsel, if I may just
continue
kind
to.
of, Counsel, if I may refocus just on a couple of things. You talk about the Burbank factors in your brief, and I guess I just want to clarify, your brief seems to suggest, at least it alludes to it to me, that all of those factors must be satisfied. But I just want to confirm, other than temporal proximity, do you agree that any of those factors on their own independently could be sufficient to show retaliatory motive?
No, Your Honor. I don't think all 5 factors in the Burbank need to be proven, but there are
So you agree the law doesn't require that you have to establish all of those?
That is correct, Your Honor.
Okay, and I understand that you believe there may be more facts there, but I guess my question is, independently, the law permits, other than temporal proximity, that any one of those could support that?
Yes, Your Honor, but one factor of 5 factors being the only factor proven by the employee does not make a compelling argument that there was any motivation based on the protected activity.
So
Mr. Horner,
sorry, go ahead,
so
Justice Brody.
you follow up.
Okay. Well, Mr. Mehrmann's claim seemed to be supported by 2 factors in particular: the inconsistencies between the college's proffered reasons for termination and its later actions, as well as the shifting explanation. So can you briefly address what the board relied upon with regards to his claim? Certainly,
Your Honor. It's our position that they are not shifting, but more so compounding. As an initial matter, as I previously discussed, there was a decreasing interest in the program, and it was the college's determination that the program should be eliminated. So in Mr. Mehrmann, and I kind of alluded to it earlier, he just wasn't a good fit in the program in 2022. So the initial sort of reason for his termination was the elimination entirely of the music program
Does that,
as a degree.
let me interject there.
Yes,
The idea being that you're suggesting that there's a lack of interest, maybe there's a lack of need or a diminished need for him. But at that exact moment, late spring, you're hiring another person.
correct.
That's at least a record that submits conflicting inferences about what's the real reason.
And I understand that. I mean, as part of the teach out plan, then they needed faculty to teach.
Right, but that's where they were when they said they didn't need him. They were bringing in somebody else.
Correct. And they brought in someone else. And this is, again, the compounding reason is that Mr. Mehrmann didn't have a master's degree, which it was a determination of the college based on the Higher Learning Commission's minimum requirements that those teaching those classes needed a master's degree. And the college could not, once they determined that he did not, they could not allow him to teach further.
But do you see where that whole idea of shifting explanations is recurring before our eyes?
I understand it. I understand what you're saying, Your Honor. But you know, the mere fact that there's shifting explanations or differing inferences alone does not establish a motivation. The grievance itself was based on Mr. Mehrmann's complaint that he was not given a particular music class, and it wasn't.
Right. But the substance of the grievance is neither here nor there, right? It's whether he was retaliated against because he filed it, regardless of its subject matter.
Correct. And it's our position that because the baseless nature of the grievance, the fact that the grievance didn't name Ms. Becker individually, that there's really no animosity in the record that could show that there was any animosity towards Mr. Mehrmann for the mere filing of the grievance. I think there was an escalation of tension between members of the department and Mr. Mehrmann later in 2022. For example, there was instances where Mr. Mehrmann was asked to review particular documents for the review for the ICCB. He declined and said, "I'm not working for free." There was another instance where he was asked to fix equipment or to facilitate the fixing of equipment, and again declined because his release hours were cut. He refused to take particular classes on days. He demanded release hours be instated. So there was, and that's what I mentioned earlier regarding a lack of team players and sort of insubordination in the sense that there was frustrations with Mr. Mehrmann that were unrelated to his grievance, but rather.
You don't think that the record would support the inference that filing a grievance might also be viewed as being a lack of a team player?
I believe it could be inferred, but just the baseless nature of the grievance, I don't think.
Counsel, which side are you arguing for? You seem to be making it pretty clear here that the grievance is one of the reasons that he was terminated.
I'm making my argument is that the grievance was not why he was terminated whatsoever. It was not related to the grievance. The grievance itself was baseless. There was no, it was withdrawn by the union. They issued an apology. There was no such a grievance would not agitate or agitate any of the department heads or other employees of the college.
Counsel, also I want to follow up on something else that you said. You suggested that, once they learned he didn't have a master's degree, that then he could not teach any of the courses, and that may be a reason that another teacher was brought on. But I thought the record also indicated that once the teach out plan was developed, that to accomplish that, the college had to offer more music technology courses per semester than he could teach as an adjunct.
That is correct.
not because of necessarily his lack of a master's degree, that just the number of courses
To
would be
effectuate,
beyond his capabilities.
yeah, that's correct. To effectuate the teach-out plan, there's more classes.
So it seems like if you ever needed him, it was at the moment that you terminated him.
Well, that's the difference that could be made, but again, it's our position that
Would it be a clearly erroneous inference for the board to have made it?
we believe so.
I want to follow up also on the ICCB policy, where you've indicated, instructors were expected to have graduate work through master's degree in assigned field or area of responsibility, except in those areas in which the work experience and related training is the principal learning medium. So I go back to my earlier question as to whether or not that was evaluated as to whether his experience might have been sufficient without the degree.
Yes. Well, Your Honor, I believe that is for the PCS 1.2 classes, which may be career and technical learning, whereas the PCS 1.1, which what the music classes would be considered, it's an AAS degree, it's an Associate of Applied Sciences, it's under the Arts and Humanities Department.
But you weren't going to offer that anymore, correct? You were moving to a certificate program?
Correct, but
so would those other level 1 courses, as you're calling them, be available?
the 1.1 classes, Your Honor?
Yeah.
Yes, they would be available, and they would require a master's degree to be taught.
I thought, I'm sorry, I must have misunderstood what you just told me. I thought you were told me there were classes where the related training and work experience would have been sufficient to teach those classes.
Yes, Your Honor, those are for the PCS.
Which classes are those?
The PCS 1.2 classes. Those are.
And what is PCS 1.2?
The PCS, as it was testified to by Dr. Becker, just is for the program code, and it just refers to.
Are those available in the certificate program?
I believe so, Your Honor.
Thank you. You may continue with your argument if you have anything further. I don't have any further questions on that issue.
Okay. I don't have any other further argument this time.
All right, at this time, Justice Doherty, any further questions? No. Okay, thank you. Thank you. You'll have time on rebuttal. All right, at this time, then, Ms. Brown.
Good morning, Your Honors, and may it please the court. I am Assistant Attorney General Megan Brown, and I represent the state respondent, the Illinois Educational Labor Relations Board. I'm going to be splitting respondent's time with counsel for Mr. Mehrmann. I will argue the first 12 minutes, and Mr. Baker will argue the last 8. You can direct any questions about any of the topics to either me or Mr. Baker. This case comes down to one primary factual issue: whether Mehrmann's grievance was a motivating factor in the college's decision to terminate his employment. The board found, as a matter of fact, that Mehrmann's grievance did motivate the college to terminate his employment. And because there's evidence in the record to support the board's finding, this court should not disturb the board's decision. At the outset, I would like to make one preliminary point. The standard of review when determining what motivated the college's adverse employment action is manifest weight of the evidence. On the first page of the college's brief, it argued that the board conceded that the standard of review is clear error. That's slightly incorrect. While review of the board's ultimate determination that the college committed an unfair labor practice presents a mixed question of fact and law, the subsidiary question of the college's motive for taking its adverse employment action is a question of fact, reviewed under the manifest weight of the evidence standard. And that means that, the board's factual findings are prima facie true and correct unless the opposite conclusion is clearly evident from the record. And generally, affirmance is proper if there's any evidence in the record that supports the board's findings. Additionally, the board did not concede this point. We made this point in our brief at pages 18 through 19. So I'd like to move to Mehrmann's prima facie case. As counsel for the college discussed, unfair labor practice can be proved by 3 factors: by preponderance of the evidence at the prima facie stage by the employee. The only question in this case is whether the adverse employment action resulted in part because of the employee's engagement in protected activities. Here, that means the only question is whether Mr. Mehrmann's grievance motivated the college's decision to terminate his employment. And that can be proved by circumstantial evidence set out in the City of Burbank factors. Mr. Mehrmann pointed to 2 City of Burbank factors. The first were the shifting rationales for Mehrmann's termination, and the second were the inconsistencies between the college's proffered reason for Mehrmann's termination and the actual state of affairs at the college. So as we've discussed, the college's explanation for Mehrmann's termination shifted over time. At first, the first email was, about 100 words saying that Mr. Mehrmann was being terminated without cause, so basically providing no explanation whatsoever. And then after Mr. Mehrmann inquired as to why he was being terminated, Segoviano informed him it was because of a lack of sustainability in the music technology program. And then about 9 months later, once proceedings before the ALJ and the board began, only then did Mr. Mehrmann hear that he was actually being terminated because he lacked the qualifications to teach the class, even though he had taught the classes and the degree program for nearly 20 years. So over time, the board could reasonably look at the evidence and come to a finding of fact that
if I can just interrupt for a second here on this, opposing counsel really doesn't look at this as, quote, shifting rationales, but rather compounding facts. How do you disagree? Do you disagree with that? And why isn't he right with respect to that? I mean, wasn't one thing added to something else to give the basis for the dismissal?
I mean, I do disagree with that for a couple of reasons. The first is that when Mr. Mehrmann inquired as to why he was being terminated, that was an opportunity for the college to explain all the reasons why it chose to terminate Mr. Mehrmann's employment. But at the time, it only cited the lack of sustainability for the music technology program. And, Dr. Becker was the one who basically decided that who said, or at least testified, that Mehrmann needed a master's degree. But if you look at the exhibit, that's exhibit pages 301 to 302, Dr. Segoviano said that she conferred with the interim dean of arts and humanities as to why Mr. Mehrmann was going to be terminated. And that interim dean was Dr. Becker. So before Dr. Segoviano sent this email to Mr. Mehrmann explaining the reasons for his termination, she talked to Dr. Becker. I see no reason why at that time they couldn't have explained to him, hey, thank you for your service, but we've just realized while we're doing our sort of certification process that you don't have the qualifications to teach these courses anymore. I don't see why that couldn't have been brought up in the email that Dr. Segoviano sent to Mr. Mehrmann. And then regardless, I can see how this would be somewhat of a difficult question of fact, but it is the board's prerogative to be the finder of fact in this circumstance. And when it looked at the sequence of events, first an email without explaining that he was being fired without cause, then an email saying that he was being fired because of a lack of sustainability. And then once litigation essentially began, a rationale that he lacked qualifications, it was entitled to look at that evidence and see a shifting rationale. And then the other City of Burbank factor, each of which, by the way, is sufficient on its own. If you look at an appellate court case, Pace Suburban Bus, is the inconsistency between the proffered reason for discharge and the actual state of affairs at the college. As your honors pointed out, the Teach Out program was going to be continuing through December 2023. So at the time of Mr. Mehrmann's termination, there are going to be at least 3 more semesters of the music technology program that were going to be taught at the college. And that's not even including the certificate program, which was going to be revamped. So as you have noted, there was a great reason for Mr. Mehrmann to stay on to teach the classes that he himself developed as the program came to an end. And as for his lack of a master's degree, the board reasonably found it was implausible that all of a sudden, after 19 years and after the college was on notice, I mean, since he was hired, that he lacked a master's degree. It's quite fishy for that suddenly to become a problem the semester after he files his first grievance. And I would also note that although the ICCB requirements do show that for these transfer courses, there needs to be a master's degree. As you note, some of these career-focused courses simply require just experience in the field. And in that document, the ICCB document that the college presented on exhibit page 271, although the board did not explicitly note this, I'd just like to point out that the document states that there is greater flexibility in requirements for both physical education teachers and music teachers. It would have been reasonable, I think, for the college to investigate whether flexibility would have been appropriate in the music department. But we don't have any contemporaneous evidence whatsoever showing that the college investigated this issue. And so because there is record evidence that support each of these two City of Burbank factors, the board's decision that Mr. Mehrmann made out his prima facie case is not against the manifest weight of the evidence, and this court should defer to that factual finding. And the last question is whether the board correctly determined that the college failed to show that it would not have terminated Mehrmann's employment absent his grievance. The college question of motivation still, according to Speed District 802, is still a question of fact, and the college simply did not provide any contemporaneous evidence showing that Mr. Mehrmann was terminated for a lack of a master's degree. And again, as has been pointed out, the question of the lack of sustainability for the music technology program is dubious, considering that they needed someone to teach these classes, two someones to teach these classes for 3 more semesters, and then potentially for even further semesters as the music technology certificate program got revamped. So, there, without specific evidence, this is the college's burden to show the reason, the determinative reason why Mr. Mehrmann was fired. And based on the evidence in the record, or the lack of evidence in the record, the board could properly infer from all of this evidence that the determinative reason here was Mr. Mehrmann's complaints and grievance. So at bottom, Mr. Mehrmann filed his grievance right before the start of the spring 2022 semester. That was his last semester that he was able to teach at the college. And there is simply no contemporaneous evidence in the record that establishes a plausible alternate reason for his unceremonious dismissal after almost 20 years of working and developing the music technology program at Southwestern Illinois College. Because there is evidence in the record that supports the board's findings, this court should affirm. I see the remainder of my time to Mr. Baker, unless this court has any questions.
Any questions? I don't see any. Thank you. Mr. Baker?
Good morning. May it please the court, counsel. Much of this has been stated already, but this really is the review of a finding of fact. The question of what motivated Becker's decision to terminate Mehrmann is a question of fact. The standard of review is very, very high here. And so while different people might disagree on whether Mehrmann proved his case, the bottom line is it's the board that gets to make that determination. And unless there's no basis for it, unless it's completely erroneous, this court gets against the manifest weight of the evidence. This court has to affirm that determination, and I think that there is plenty of evidence to support that. I would like to address a couple of points that were brought up during the questioning of counsel. First of all, the idea of when did the university or the college know of the master's degree? They knew about the master's degree all along. In fact, I think that the documentation that they presented to demonstrate that Mr. Mehrmann didn't have a master's degree was dated 2007. So they knew about that for a long time. Second of all, they reference that the rules changed. I don't know where that comes from. There was an ICCB memo, and we've outlined this at pages 23 and 24 of our brief, but there was an ICCB memo dated March 12, 2018, that talked about the requirements for the master's degree. And I think it's important because it's this PCS 1.1 and PCS 1.2 courses. They want to contend, well, these were PCS 1.1 courses, but they weren't. They've presented no evidence other than Becker just saying, oh, yeah, these were PCS 1.1. There's no demonstration of that. And when you look through it, again,
Isn't that competent evidence from the dean of the department?
no, because she had no basis for it. When she was asked about it, she couldn't explain where that came from. And when you read through the program classification structure, which is a legal document, it goes through and explains that PCS 1.2 are instructional offerings that are technical in nature and are designed for entry into a specific occupation or career. Conversely, PCS 1.1 courses are designed for more rigorous academic study. There was no contemporaneous documentation, no documentation at all, showing that the college believed these to be 1.1 courses. Nothing. And they historically were never treated as 1.1 courses. They were always treated as 1.2 courses because this was the idea. And as counsel pointed out, the rules from the ICCB specifically point to music instruction as being a specific example of that. And the fact that they were moving, they're not eliminating the music program, which I think is what they're trying to suggest. They're not eliminating that. What they are doing is they are moving from a degree-based program to a certificate-based program. All right. So clearly, if ever you needed a master's degree, it would have been when you were focused on a degree and not when you are now focused on getting a certificate. The certificate is just that. It's instruction by professionals who have professional expertise. And that's exactly the direction in which the college was going. And so while they were phasing out the degree program, they were continuing on with this, with the overall classes. And I mean, I think even today, I know even today, those classes are still exist. They still list in their on the online catalogs. They're still teaching these courses today. So the idea that Mr. Mehrmann's background was not competent or not consistent with what they needed is just not accurate. And I think that the board looked at that and said that's not true. And because of that, now are they required to draw the inference of a retaliatory motive? No, they're not required to, but can they? And that's the question for this court. Can they draw a retaliatory inference? And they most certainly can, based upon the evidence that has been presented. There are a couple of other points that I would like to make about some evidence. One of the things, and part of the reason why such deference is given to factual findings is because finders of fact are there. They're listening. They're reviewing all of the records. They're involved. And Becker's testimony was hard to accept and hard to believe, and that's what they found, that it was not accurate. And so we look at Becker, and Becker says in one of her pieces of testimony that the union president came up to her and apologized for the fact that Mehrmann had filed this grievance. Well, when that union representative testified, he said, that's not accurate. In fact, I actually helped draft the grievance that Mehrmann made. And so, my interpretation of that, or at least that I thought could be drawn, was, look, this is her being frustrated that Mehrmann had the audacity to prepare a grievance. She is frustrated by the fact that he would do that. And here she is creating this explanation that the board member, or excuse me, that the union board member was apologizing for it. How dare he do that? But again, that's looking at how dare he challenge her. And that's really what the issue is about. Her motivations, her being frustrated by the fact that he had the audacity to challenge her. That's what retaliation is. And he had a right to file the grievance. We all agree on that. There's been no dispute as to that. The question is, can the board permissively draw the inference that that was retaliatory? And of course they can. They've outlined the factors. We've gone through the city of Burbank factors and have established that. And I also would like to point out to one of the questions that was raised earlier about whether these were just a continuance of, not necessarily shifting explanations, but more explanations. That might be a little bit more palpable or easier to believe if there was some contemporaneous documentation that Becker had at the time that she made this decision. One would assume that if Becker was making this assessment, that there would be some documentation, some internal notes, some emails, something, some communication that she apparently had with somebody saying that, well, it's because he doesn't have a master's degree. There's none of that. The very first time she ever bothers to mention that is at trial. So again, if you're eliminating a person who has been there for 20 years, 20 years Mehrmann was there. Nobody ever said he wasn't good. He built the program. Everybody seemed to like the guy. Well, with the exception of Becker, everybody liked the guy. So he's there for 20 years. And you don't even bother to tell him, oh, this is the reason why we're doing this. And you don't have any documentation at that point. It just reeks of the fact that this is an ex post facto justification that they dig through and they come up with, this is something we can use at trial to justify our decision. Again,
Oh, if I could just, I know you don't have too much time left, but if I can just focus. So we're focusing now on your comments on the grievance and whether that was the motivating factor. But of course, the other part of this is whether indeed there were any legitimate business reasons to terminate the employment. Would not the requirements of the and I'm sorry, I've lost the board that required not the IERB board, but yes, thank you, that required the masters. Didn't the college have to really follow those guidelines to perhaps keep some sort of accreditation or reputation? Why were things like this not legitimate business reasons?
Well, they have to be legitimate and they have to be accurate. And that's the problem. I mean, so, they can come up with there are all sorts of things that are legitimate. The question is whether they were truthful, and they have to establish that those were the real reasons. And so when we look at it, are those the actual reasons? And I think that the board said, no. I mean, the evidence suggested that because they were shifting explanations, they didn't buy what the college was selling. And so yeah, are they legitimate? Yeah, in theory, they're legitimate, but that doesn't mean that they are the real reasons why the decision was made. And I think that's where the distinction rests. And I think my time is up, so I'll
about 12 seconds.
12 seconds, okay. So anyway, we believe that whether the panel agrees with the factual determinations or not is irrelevant. The question is whether the board could have made that decision, and because they could, we ask that the decision of the board be affirmed. Thank you very much.
Thank you. At this time, thank you very much, counsel, all of you, for your arguments this morning. The court will take
rebuttal.
I'm sorry, I didn't see. We have rebuttal. I'm ahead of myself. I apologize. Yes, Mr. Horner.
That's okay, Your Honor. If I just may,
I apologize.
It's okay. Counsel just mentioned the preferred reason for Mehrmann's termination. Initially, Mehrmann was terminated without cause, and he was done so because the break of service he had in the spring of 2021 restarted his equated hours. Because he did not have enough equated hours, pursuant to the collective bargaining agreement, the college could terminate him without cause. So the college did not require a legitimate reason for his termination at the time he was terminated.
Does it have to provide such a reason if he's made a prima facie case that he was discharged because of his grievance?
Could you clarify that, Your Honor? I'm sorry.
I can repeat it.
Yeah,
if we're at the point in the case where we're talking about the legitimate business reason, it's because he has made his prima facie case of being discharged for his grievance. So given that, don't you have to, under the applicable analysis, show that there was a legitimate business reason, that you can't rely on the no cause needed?
Yes, Your Honor. Then there were legitimate business reasons present. Most notably, without the master's degree, students taking Mr. Mehrmann's class are at risk of not being able to transfer their credit hours. Uh, as such, that is a legitimate business reason to remove him from the program so that students can properly transfer those credits and earn.
So
Was that-
you've indicated,
that-
and I think it's sort of plausible that, well, maybe they just didn't think to go back and look once they settled on a master's requirement or learned of a master's requirement. But is there any evidence in the record that they did a systematic review of all faculty to see if anyone else was lacking a master's that wasn't required when they were initially hired? Or is it just Mr. Mehrmann?
I do not believe that there is anything in the record regarding a systematic evaluation of all faculty.
Does that support the inference drawn by the board?
It is our position that it does not. Um, um, the it's obviously Mr. Mehrmann had been at the college for quite some time, nearly 20 years. For the bulk of that time, master's was not required. This could have been a simple oversight by the college, but as soon as the proper people learned of it, obviously this wasn't it wasn't Dr. Becker who initially brought this matter to the college's attention. It was Christian Rupert when talking with Ed Jacobs. So it's not a unilateral animus towards Mr. Mehrmann for filing the grievance on behalf of Ms. Becker. Or Dr. Becker. It was the college finding out and reacting accordingly.
Counsel, could you also respond to the issue that was raised with regards to standards of review? And do you agree with Ms. Brown's clarification on that issue?
I do, Your Honor.
Okay.
Warner,
And
you
further,
still have- Go ahead.
sorry, and further, counsel, Mr. Baker suggested that these really had been, I think it was PS 1.2 courses and always treated that way historically, and that music was one of those under the guidelines that could have more flexibility. Do you agree with those assertions as well?
I do not, Your Honor. The music program itself falls beneath the arts and humanities. It has always been treated as a 1.1. Dr. Becker testified to this effect. While there are
What was the underlying basis of her classifying it as such in that testimony? Did she provide that in the record?
I believe that there was a class list, and she just indicated that the classes listed were PCS 1.1s, and therefore a master's is required.
Do you agree with the assertion Mr. Baker made that once this moved to more of a certificate program, that the need for a teacher with a master's would not be required, given it was moving to a certificate program?
Well, I disagree with that, Your Honor, in that the classes would still need someone with a master's degree for the students to be able to transfer those credits, is our understanding. So obviously the college did not want to put any students taking music classes to essentially forfeit the earned credit hours that they earned.
All right, at this time, your time is up. Justice Doherty, any further questions, or Justice Landert? Anything further? All right, at this time, the court would like to thank counsel for your arguments this morning. The court will take the matter under advisement and render a decision in due course. Court stands in recess at this time. Thank you very much.
Thank you.
Thank you, Your Honor.
Thank you.